Definitely.
I'll have to convince it otherwise at some point here.
All right. We are getting started with our 10 o'clock workshop. We're going to have a few more people probably signing on over the next couple of minutes. But while that happens, let me just go over a little bit of background, and then I'll have Mitch do our introduction. Thank you for joining us for these Back by Popular Demand workshops. Throughout the month of March, we are going to be revisiting a couple of topics that were very hot topics and we had lots of questions about when we covered them last fall. So we're really lucky to have Sarah Conley Odenkirk doing 2 of those sessions, and then Bill Dambrova doing the other 2. We are going to record these sessions and they will be available on the Office of Arts and Culture's YouTube page as an archive in about a week after we host them. So if you could please keep yourself on mute during the presentation, that will help us with our recording sound for the future posting. We do want questions though, so make sure to type your questions in the chat box. We're going to monitor those as we go through the presentation, and then we'll get to them at the end. All right, Mitch, I'm going to turn it over to you.
Well, thank you, Katie, and good morning, everyone. It's great to see some returning faces and some new folks on today's workshop. We're excited again to bring Sarah Conley Odenkirk, and I have the pleasure to introduce her. Sarah is a partner at Cowan DeBates, Abrahams and Shepherds LLP's Entertainment Group with a core practice in fine arts. She is based in the firm's Beverly Hills office, where she spearheads the firm's art law practice and advises clients on matters pertaining to intellectual property, business transactions, navigating the art market, public policy, and strategic planning. Sarah provides advice to artists, collectors, dealers, and art institutions in art world negotiations and transactions. She works with creative entrepreneurs to guide them in business development, sustainable growth, and the protection of intellectual property assets. Sarah also works with municipalities to craft ordinances, policies, and procedures pertaining to public art in both public and private development. Sarah is also the author of a surprisingly interesting book about contracts for artists and other creatives in 2014, and that book is at AMMO Books LLC. So Sarah, welcome, and take it away.
Thank you very much. I appreciate being here, and we're going to get to talk today about one of my most favorite topics, which is contracts, as evidenced by the book. So anybody who has the book will recognize the artwork that is peppered throughout today's presentation by artist Joe Beal, who is an artist here in Los Angeles. So I'm, as you know, going to speak about contracts today. For a lot of people, contracts can be very daunting, but I am going to convince you today that contracts should be your friend. It's really important to have contracts in a lot of different situations. And so I'm hoping that today we can get through the main areas of contracts, and anybody who has questions, please do pose your questions. We can get to those afterwards. I just need to be very clear that I can't answer specific questions about specific problems. I can answer general contracts law in general kind of questions, and certainly with regard to art is fine. So let's get started. If I can figure out which button to push to change my slide. Okay. We are going to start today with some myths and misconceptions. I hear a lot of different things from artists when it comes to contracts, and one is a contract must be in writing, and that is not true. So even if you don't have something in writing or you haven't signed anything, there can still be an agreement. The agreement can be an oral agreement. The problem with oral agreements, as you can probably imagine, is that it's very difficult to prove who has said what and what was actually agreed to. So without a contract in writing, it is a little bit difficult to ensure that there aren't going to be conflicts around the issue that people can't remember who did what or who said what. Next myth or misconception is we're friends and a handshake is fine. And this is one that I hear all the time, and I've in fact been berated by even dealers who say, what do we need a contract for? You know, I always do everything on a handshake. It's the art world. We do, you know, we do things on trust. It is true that relationships are based on trust. And it is also true that oftentimes things do happen without a written contract. The problem is that, you know, if you don't write it down, as we just discussed, there is certainly the possibility that there are honest misunderstandings in terms of what people have agreed to. And frankly, if you agree to the way that something is going to be done, why not write it down? It's not that hard. And, you know, really, especially when you're dealing with people who you trust and enjoy working with, oftentimes that can be friends or you've become friends over time. It's the fastest way to lose a friend, to have a conflict over an agreement. And again, you know, oftentimes this can be an honest misunderstanding, but a misunderstanding nonetheless that can create stress and tension. So make sure that you have more than a handshake. Next is contracts are so complicated, and that is true for some contracts. And it is true that sometimes contracts are way too long and unnecessarily long to affect exactly what they need to. But that doesn't have to be the case. Contracts can be simple, straightforward, in plain English, and can just focus on those things that are important in order to get the deal done. So I will say this a couple of times. If you receive a contract and you don't understand it, that's the perfect time to call a lawyer. I realize calling a lawyer is most people's least favorite thing to do, maybe going to the dentist, but calling a lawyer is definitely up there with not favorite activities. A little bit of time and money spent up front reading a contract and understanding can save you a ton of time on the back end when you have a miscommunication or things start to fall apart. So if you don't understand something, definitely seek help. And that can be a very efficient way of making sure that you move forward on a good note. One of the things that I will say I think people find most complicated tends to be the boilerplate language in contracts. So we're going to go through a lot of that boilerplate so that hopefully you feel a little bit less intimidated when you see that language, and you can understand, you know, after having spent years reviewing and drafting contracts, what I can do when I see a contract is break it down just by looking at the different areas, and we'll talk through those areas so that you can, if you break it down, it ends up being a little bit easier to analyze and to feel comfortable with each of those sections separately. Okay. Next myth or misconception, trust me. And of course, that's always attributed to the lawyers, but in fact, lots of people say, oh, just trust me. Don't worry, we'll get through this. I'll take care of you. I'll make sure that you're compensated. Understand that even if you have a contract and it's in writing and everyone has signed, if someone says, trust me, I'll take care of you, don't worry about what's in the agreement. You do need to worry about what's in the agreement. One of the items of boilerplate that we'll take a look at a little bit later is an integration clause, which essentially says that anything that's not within the contract is not part of the deal. So even if people make oral agreements and promises outside of what's on that contract, you may have trouble enforcing that. So if there's a trust me, I'll take care of you conversation that's happening, create an addendum, do something to amend the contract, and make sure that that is also in writing. And the last thing that we'll address here is you must be looking for litigation. You know, oftentimes people see contracts as the precursor for litigation, but I want to encourage everyone to think about contracts as a tool for communication, a tool for setting out those obligations and expectations. It's a good way of upfront addressing what everybody wants to see happen in a project, and hopefully confirming that everyone is on the same page. And if not, it's definitely a good time to be talking through where any disagreements may come up, or where any miscommunications are happening with regard to expectations. And I lied, there's one last one. That's easy, I'll do it myself. Contracts should be looked at as something that anybody can do. However, there are, of course, some technical aspects of contracts. So again, it's not that ordinary people who are not lawyers can't write their own contracts. Of course they can. But certainly if you're presented with a document that you don't understand, time to get some advice. Or if it's a particularly complicated situation, it always makes sense to have somebody else draft that up to make sure that everything is covered. So contracts are definitely technical legal documents, but people create contracts amongst each other all the time without lawyers getting involved. So just because a lawyer is not involved doesn't mean it's not a viable contract. So another area that, and I think we may have touched on this at the business practices conversation we had a few months ago, but it's very important when anybody is approaching a business transaction or an opportunity to create artwork or be engaged with another party in whatever way we're talking about. Getting what you need is very important. Part of that is learning how to negotiate. And I know that oftentimes creative people have a particularly hard time feeling comfortable negotiating. The first thing that I always talk about is asking for what you need. Sometimes it helps to make a list of all of those things that you want to get out of a particular relationship or project, and so that you have an idea of what you want. Oftentimes people will go into agreements very excited about one aspect of it, but not really thinking through everything that is needed in order to make that a successful and problem-free transaction. Ask for what you want. So once you figure out what it is that you want to see out of an agreement, ask for that. The worst that can happen is people say no. If you are rude, demanding, and unpleasant to work with, yes, people will say no right off the bat, and they will see that if that's the way you're behaving now, this is likely how you're going to behave throughout. And the same goes, on the other side. Pay attention to those kinds of behaviors. But as long as everyone is being reasonable and cordial about the negotiations, if you ask for what you want and it's not possible, the other side will say no, and it is highly unlikely that they will simply walk away. So I think what happens sometimes is people are afraid that if they ask for what they want, the other side is going to walk away and the deal is going to fall apart. That's generally not the case. So it's important to talk yourself through that and get over that fear so that you can ask for what you want and what you need. It is true, as I said, if you're too persistent, that can damage the relationship, but a little negotiation never hurts. And certainly you don't want to sign a contract and obligate yourself and then feel like, gee, I should have asked for more. I definitely feel like I could have gotten more out of this deal if I had only asked. The other thing I would say is an important aspect to keep in mind is being flexible. And I talk about this oftentimes in terms of having empathy. So communication and empathy are the two things that I'm going to hammer on throughout this presentation, and I talk about it all the time in my practice as well. It's very important to be flexible, to understand where the other party is coming from, and to think along the lines of how do we get to a place where we can both get what we want. Oftentimes that is something that is absolutely obtainable if you just listen to the other side. The other thing is that without listening, sometimes we end up rejecting perfectly good options that are being presented to us because we're too focused on what it is we want. So both having a good understanding of what we want and need in the relationship, as well as listening to the other side, hearing what it is they want, and understanding why they're asking for things that they're asking for. Combining those two techniques is going to take you far in terms of negotiating and getting what you need in contracts. Okay, so before a contract can be formed, there has to be an offer and acceptance. And these are sort of the two basic things that happen as we're moving toward a contract. An offer is a promise to do something in exchange for compensation. That promise can be at a designated place and or time. And that compensation can be, any number of things. The compensation can be reciprocal action. The compensation could be cash. So compensation is a fairly broad category. Though generally speaking, we're talking about getting paid, especially if you want to be an artist who has a sustainable practice. An acceptance can be expressed in words or implied by actions. So that's why it's important that you not start acting on the agreement or the arrangement before you have an agreement in place. Because if you start taking action, if you start doing things, then the other party can claim that they're relying on what you're doing. And so then you get into this position where you've got sort of an oral contract, you don't yet have your written contract. So that's why it is really important to start this process of talking through and drafting the contract before you start taking action. So acceptance normally conforms exactly to the offer. This is something else to keep in mind. Somebody offers you a certain opportunity. When you accept it, you're accepting it based on exactly those terms that have been offered. Sometimes if you accept but you add additional terms, that's considered a counter offer, which then has to be accepted by the original party in order for you to have a contract. So going back and forth is no problem. Just understand that if you are asking for anything different, you've essentially said, I don't really like your offer, I want something else. So that you're in the negotiation phase, nobody has indeed at that point accepted and agreed to anything. What we hope to eventually get to is a very important concept, meeting of the minds, which sounds very important, but it is in fact an important part of forming a contract. This is an essential prerequisite for forming a contract. It is mutual assent or meeting of the minds, meaning that you both have gotten to the same place, everybody understands the same thing. Through mutual assent, parties may form the contract pursuant to which performance will be necessary. So it is this that kind of starts the point at which you can say we now have an agreement. So once you've gotten to this place, you're ready to start negotiating the details. So here we are negotiating the details. All right, you've agreed to work together. You've agreed on what that purpose is, what the project is, and now what are the specific terms of the deal going to be? We've already talked about going through offers and acceptance, the offer and acceptance stage as part of the negotiating. If there are deal breakers on which you cannot agree, it's really important to figure that out. And the best place to start is with an issues list. You can write down what it is you need, and we talked a little bit just a minute. You need getting what you want. So writing down a list of issues is important, and knowing where your bottom line is, where your line in the sand is going to be. Where is it where you cannot go forward with this deal? Oftentimes it has to do with money, so it's important to know again what it is you need in order to move forward. But it can be something else too. It can be that you don't want to do a project in a particular location. You don't want to have particular parameters put on your creativity. So figure out exactly where those lines are and what issues need to be worked through in order to get to a final agreement. This also involves making sure you're comfortable with your priorities, what's most important, what's least important, figuring out where that wiggle room is. And once again, making sure that you're approaching this process with empathy. I told you I was going to talk about this a lot. So the negotiation can often come through multiple exchanges back and forth. And again, keeping an eye on what works for you and what works for the other party will eventually get you there. Okay, so breaking it down, what are the terms of the contract? This is where we start to get into the actual contract creating part. The main body of a contract will contain the terms of the contract, and that's going to include things like payments, the amount of payments, the schedule for payments, the schedule for performance, representations and warranties. We'll get to all of this in a little bit more detail. Everything that each party is committing to ensure that, that the contract can happen, when it's going to happen, and who gets what in the end. So the initial considerations, and this is, what we're going to do is now go through what a contract looks like. So at the very top, when you first look at the first page of a contract, some of the things that you're going to see there are going to be things like parties to the contract. This is important. So the parties to the contract indicate who you're contracting with, who are you negotiating with, may be different from who you're actually signing a contract with. So it's important to know if there's a difference between the person who is representing a particular entity and that entity that's actually signing on to the contract. So pay attention to that. See exactly who it is who's going to be held responsible for the terms of the contract. It may be that the person that you're negotiating with ultimately isn't the one who's going to have to answer to the contract. And that can be really important to know up front. The next thing you'll see are recitals. And this is sort of the technical term. Oftentimes you'll see the word whereas before each recital, but sometimes it'll be listed out in more of a conversational or sentence, sentence format. The recitals tell the story that lead up to the contract. So it may say things like, whereas artist is in the business of creating artwork, and whereas the developer is in the business of building buildings and wishes to hire the artist to create a work of art for the project. So it's going to set out the story that leads up to this contract. This can be really important because it establishes the basis for the contract. And it also can set out some assumed facts that you want to make sure you agree with before you move on beyond that. So even though the recitals may look like they're formulaic and not important, they can be very important. So make sure you read through each one of those, agree with, you are pointing that out and making those corrections. Following the recitals, you'll see language that's going to start to address the nature and scope of the agreement. What is this agreement for? How big of a project are we talking about? What exactly is going to be the nature and scope of this project? This will also be the place where you want to have it explicitly laid out exactly what you're receiving in exchange for your labor or for your money, depending on which end of the contract you're on. What's the compensation? What are the responsibilities and expectations that are going to be laid out in the contract? And those things, of course, need to be the same as what was negotiated in that initial negotiation phase. Finally, time. So time is super important. Almost always time is going to be a crucial element of contracts, but sometimes, some contracts are more flexible than others. But be very aware of how long you have to perform the project or the duties and responsibilities that are laid out in the contract. How long do you have to do the work that you're expected to do, or how long do you have to pay for the work that you're asking for? This can be a really big point of controversy if, say a project has a very short time frame and it's going to take you a really long time to do the project that's been scoped out in the nature and scope part of the agreement. So pay attention to the time frame, of course, and look for words like time is of the essence. This is a term of art that you'll see oftentimes in contracts. Time is of the essence, meaning that it is really important that you do your work on time because we have other obligations that are going to be affected by this. This can be particularly important when we're talking about projects that are integrated into larger projects, either construction projects or presentations of some sort, so that the way that your contract lays out and the way that your behavior affects others is really crucial and important to take into account also. You need to understand that as you're entering into a contract, understand the bigger picture in which your agreement sits. It may be that it's standalone, but if it is part of a larger project or set of obligations, you need to understand how your actions and behaviors affect other things that may be happening at the same time. Okay, so once we've laid out these basic initial considerations and parameters, we get to the heart and soul of the agreement. So what possibly could be the most important thing here? And I think we can all agree that money is a very important part of contracts. Once you have those initial considerations established, you can then start thinking about the money and what should the money be here. Obviously, this is a crucial part of negotiation and tends to be one of the areas in which people have the most difficulty. And frankly, most people have a hard time talking about money. Most people don't want to be seen as greedy or offering too little for the things that they're asking for. So money tends to be a complicated issue on a lot of levels for a lot of people. That said, it's important more than ever in this area to not only be very clear about what you need, but also to be understanding of what the budget is and what the abilities and expectations are on the other side. So this is where we get into budgeting. Budgeting is often rushed. A lot of times artists will forget to add things like overhead or other costs that are going to be involved. They're just looking at that exciting project that's going to be created and how much the cost is there. And sometimes also artists are very eager, and this is not limited to artists. Anyone who is interested in entering into an agreement, the project looks so exciting, I want to do this, tends to be a little bit optimistic at the beginning about the budgeting and what it's actually going to cost to do something. And this can be very dangerous because as you get further into a project and you've put in the work and the time, it makes things uncomfortable and unpleasant if you're not able to actually afford to do this contract that you've agreed to do. So things to look at would be artist fees for obviously art contracts. In most circumstances, artist fees tend to be 15 to 20%. That's going to obviously vary depending on the overall budget, but 20% tends to be a pretty good benchmark to think about. Other things to think about are overhead costs. If you're an artist who has a studio, what are the costs of running your studio? You can't actually put that in as line items, but you need to understand what it costs you as an artist to produce the work that you're producing. So think about that overhead cost. Think about production costs. That may be fabrication. It may be something that you're doing within your studio. It may be assistants that you have on hand. What are those production costs? Then the cost of installing a work or performing a work, also important to pay attention to, obviously. In a lot of situations, you as the artist can't do these things alone. So it's important to think about who else do I need to subcontract with. That's true for production as well. But certainly for the installation or the performance of works, what team are you going to need in order to execute that, and what is the cost? And then the last thing, just generally speaking, that really should be considered in budgeting is contingencies. Contingencies tend to be around the 10% mark. So what you want to make sure that you're considering and planning for is the fact that in almost every situation, there are bumps in the road, things come up and don't go as you expected, and it costs money. It always costs money to take care of things. So it's important to make sure you've got a little bit of a cushion there to deal with that. So going through this budgeting process as part of figuring out what you need in a contract in terms of being paid, really crucial at this point. Once you get through that, then thinking about how are the payments going to happen? Is this going to be a lump sum or over time? Generally speaking, when you're talking about larger long-term projects, there are going to be payments made over time. Everything is not going to be paid up front. And of course, in art contracts, we often have to deal with the fact that the people who are contracting with artists are used to contracting with other service providers, other contractors, literally contractors when you're talking about construction projects. And the way in which the money flows for those projects often is very different from how it flows for artists. So understanding from your production standpoint, what do you need at what point so that you're not having to take money out of your pocket? And how do you convey that to the other side and explain to them and show that you may need the payments to be split up differently than may otherwise be offered due to your underlying obligations. And then, of course, the schedule. So the schedule, of course, pertains to when you need the money in order to execute the project. but also understanding how that relates to the overall schedule for delivery, and figuring out how to best break down that payment structure. So as I just touched on, performance schedule obviously is really tied into the money part as well. And so what we tend to look at are milestones. When we're talking about the production of projects that you're used to doing, it's much easier because then you know pretty much how your projects roll out. What happens first, what happens second, where are good points at which to communicate where you are in your schedule, and what are milestones that can be offered in terms of proof that you are moving along on your obligations under the contract. Again, we talked a little earlier of about time is of the essence. Again, very important to understand how those milestones and performance schedules fit into a larger picture. Sometimes if you're dealing with fabricators have a hard time just switching projects in and out. They've scheduled and booked time within their facilities to produce something. So it may be that time is of the essence on that side. If a project is part of a larger construction project, other aspects of that project may be contingent on your performance. So again, time is of the essence. And once again, along with empathy, communication is key. Very important to be communicating throughout. This is not just something that happens during the negotiation phase and then you're done. It's very true that communication is the heart of what keeps these contracts rolling along smoothly, especially if changes need to be made or schedules need to be adjusted. Always think about communicating rather than hiding the ball and hoping for the best as things move forward. So that tends to be, again, we're kind of going in order through what a contract should lay out. And when you get to about the middle of the contract, you're going to see areas that address duties, representations, and warranties. We've talked about scope and performance and payment. This is going to be a little bit more of a detailed explanation of what does each party have to do. Things that will be, so let's see, where's my button again? Okay, here we go. So obligations, facts, and guarantees. These are the main types of things that you'll see within the duties, representations, and warranties section of an agreement. Things like originality. So artists often have to represent that the work that they're providing is original. They haven't copied it from anybody else. There are no liens on the work, liens meaning other obligations. So the person who's contracting wants to make sure that whatever it is you're going to deliver doesn't have any other obligations or outstanding debts sitting on it. No pre-sales. If it's something that you're presenting, say, for a gallery show, oftentimes galleries want to make sure that the work hasn't been pre-sold, that they actually have the ability to sell the work once it comes to them. And then, as I mentioned, no copyright infringement is certainly going to be something that comes up in terms of representing that it's an original work. Other areas that can be important to address in this type of a section would be the amount of maintenance necessary to maintain and conserve works, and we'll get to some of those obligations in a moment. This must take into account factors like salt air or pollution levels, or is the work inside or outside? So representing the types of materials that are being used for physical projects. Important to take that into consideration, obviously, as you're designing the work as well. And then warranties. Warranties and guarantees, sometimes we integrate other things within the product that's being delivered. So for instance, if you're creating a work that has a computer associated with it, or other moving parts, or a light feature or a water feature, there may be some aspects of your project that you are purchasing from some other vendor, and there may be warranties that go along with that portion of the project that you're integrating. Number one, it's important to know that by integrating other people's products into your work, are you voiding a contract? And number two, if you are not voiding the contract, the warranty with that vendor, can you pass that warranty along to the end user? So if you are integrating a series of LED lights into something, is there some underlying warranty for how long those lights are going to last that you can pass along? That might in fact exceed the warranty that you are giving for your own work. But it's important to know whether those warranties are transferable and whether they endure even if you've changed the product in some way. Another thing that comes up sometimes, and this is sort of a double-edged sword, is the life of the artwork itself. So if we're talking about representing how long something is going to be in place, and this becomes really important to discuss when there's an expectation that a work is either permanent or is going to endure for a very long time. Really important to take a look at the materials that are being used, of course, but also really understanding what it is that the person who's contracting you, the person who's commissioning work, what is it that they're looking for, and you know, how long will that piece actually endure? All right, property. So two major areas of property ownership in art-related contracts: title for physical property, and obviously some contracts are not for works that result in physical property. We're talking about performances, but nevertheless, when we are talking about physical work, we need to be concerned with the title to that property. Who owns that property? Title is the documentation of ownership, and generally speaking, at the end of a contract, there needs to be a specific document that transfers title of the physical property. There can also be a representation in the contract that once final payment is received, title to the property transfers. Which actually brings me to the next point, which is that title should not transfer to the purchasing party or the commissioning party until final payment is made. Really, sometimes that title to that physical property ownership is the last thing that the artist holds as a way to ensure that that final payment is made. And sort of more of a nuanced qualification, and we can talk a little bit more when we get to risk of loss and insurance issues. I like to split the transfer of title from the transfer of risk of loss, meaning the ownership for the physical property itself doesn't transfer until the final payments are made. Risk of loss for the property, meaning who's responsible for the well-being of the physical property, transfers when control transfers. So it could be that you're delivering the artwork to the commissioning party or the purchasing party before you get the last payment. So risk of loss transfers perhaps before title transfers. In a lot of contracts, I'm spending maybe too much time on this, but the reason is that in a lot of contracts, title and risk of loss will be squished together and included in one section. So I like to make sure that they're separated, or at least there's some thought given to whether they need to be separated, so that the ownership for the property transfers hands at a different time than the responsibility to take care of the property may. All right. The other big area of property is intellectual property. And we'll talk more, is it next week? No, in a couple of weeks, we're going to talk more about intellectual property issues. So we'll save the bulk of that conversation for another day. But within the contract, you definitely want to make sure that intellectual property rights are addressed, clearly laid out. Ownership issues are established. Who owns the intellectual property? Best practices generally require that the artist retains ownership of the intellectual property, but this is where you may also have some limited licenses back to the person who's commissioning or purchasing the work, to ensure that they can do what they need to do with images of the work in order to make this contract something that works for them. So generally speaking, that's going to be things like two-dimensional images of the work can be used for educational and non-commercial purposes. Merchandising would be specifically called out as something that would be separate and would require a separate agreement, probably negotiated and figured out later. Although I will say that in larger overseas projects, sometimes we'll see, and in other projects as well, but sometimes we'll see those merchandising rights called out as being something that can be triggered down the road if certain things happen. So sometimes it makes sense to think about future rights if you want to license those future rights or allow people to do anything more than the typical educational and non-commercial uses. The other area that again, we'll talk about at greater length in the next presentation, but the other area that you'll often see spelled out here are Visual Artists' Rights Act issues having to do with moral rights. So connected to the intellectual property ownership is also the treatment of the work over the long term, addressing things like removal, relocation, damage to the work at some point along the way, and any purposeful changes that might occur to that artwork or that property. So again, that's a gigantic area that we can spend some more time on in the next presentation. All right, conservation and maintenance. Obviously, once a work is installed or conveyed to the other party, when we're talking about physical work, we're going to have issues of conservation and maintenance that need to be addressed. Oftentimes, there will be a requirement for a maintenance manual, and the maintenance manual will set out procedures for conservation and maintenance. It may also refer to the sources for materials, so that in the event that there needs to be conservation and maintenance down the road, which is almost always the case unless it's a temporary work, it may be necessary to communicate with those sources of product or parts so that anything that's needed down the road can be obtained. Repairs can also be, I've got my little words here, so that's the manual. Repairs should also be addressed. Should the artist be consulted or not? This tends to be a big question. And again, a double-edged sword, because on the one hand, you want to have artists involved in any repairs that need to happen down the road for their artwork. You want to make sure you're not violating any moral rights or making sure that the repairs are done in the best way possible. And oftentimes you can get that information from the artist. On the other hand, sometimes it can be tricky bringing artists back in to work on their work. Maybe they've moved on to a different type of work, or they didn't like something that happened in the original creation and installation of that project. So you want to be careful that artists aren't seeing this as an open door to come in and make more than repairs that are needed to the project. And this is something for artists to keep in mind as well. Like when there is an issue of repairing a work, make sure that it's just about repairing the work and not remaking the work. So in any case, very important for repairs to be done on physical works in a way that conforms with conservation and maintenance practices. And so oftentimes bringing in a professional conservator may be the best way to deal with repairs. But these things should be spelled out in the contract so that there's a clear expectation as to whether the artist is going to be involved or not. And if an artist is coming back to do anything regarding repairs or any kind of maintenance, do they get paid, or is that part of this overall payment that they're receiving up front? Generally speaking, it's good to make sure that artists are being paid for at least their time in if they're coming back and performing additional services. And then finally, relocation and removal need to be addressed. This goes back to some of the Visual Artists' Rights Act issues that we'll talk about in the intellectual property presentation in a couple of weeks. But again, making sure that we're being realistic. And this is something that I think artists oftentimes ignore, either purposefully or unintentionally, that once a work has been sold or installed somewhere, even if it's meant to be permanent, there really isn't any such thing as permanent. Things change, the world changes, especially when you're talking about work in public places. But even work in private places, circumstances change. And so it's very important to understand what your feelings are about relocation or removal of work, how flexible you can be, Again, employing that empathy around understanding why things change down the road and communicating back and forth between the eventual owner and the artist are really crucial. So for all of these issues, I think that the main takeaway here is just to make sure that the language is clear in a contract and artists are involved. And artists need to advocate for themselves as well to make sure that they're included in any of these issues that come up down the road. Okay. If anyone is still awake, I will now put you to sleep by talking about liability. So liability is actually a pretty exciting area, but it tends to be where people's eyes glaze over because we start talking about insurance. We also tend to see this word indemnification, which many people will just skip over because it just seems too difficult to figure out what the heck indemnification means. Indemnification is actually a very understandable and important concept, and one that everybody who's entering into contracts needs to understand. It means that whoever is providing indemnification will be responsible for any liability, loss, or damage that the other party suffers due to the indemnifying party's actions or inactions. So if I indemnify you, I am saying if I do anything that causes you loss or damage, I'm going to take care of it. So oftentimes what we'll see in contracts with artists is that there's a one-way indemnification. So the artist is responsible for any loss or damage that the other party suffers because of the artist's action. I like to make sure that anytime that we can, that indemnification clause is mutual. So if I do anything to hurt you, I take care of it. And if you do anything to hurt me, you take care of it. And that is sort of the basic expectation that I like to see put out in the contracts. It can be difficult, especially with municipalities, to get that mutual indemnification. Municipalities in general tend to be very risk averse, and the legal teams do not want to indemnify artists, especially because oftentimes the whole world of art seems to be mysterious and potentially problematic. So it can be difficult to get that mutual indemnification in that situation. Also, when you have parties on the other side that have really strong bargaining power and they don't have to agree to anything, it's sort of a take it or leave it deal. There's also the likelihood there that you're not going to be able to get that mutual indemnification. It can't hurt to ask. So again, always ask for that. It may be that it's not going to happen, in which case you just have to really analyze how much of a risk the project poses and what will happen in the event that you're not able to get that indemnification from the other side. That's where we get back to this risk of loss issue, which really addresses who's responsible for any damage that may occur to the artwork. In this case, if we're talking about the commissioning or purchasing of artwork, or is there any who's responsible if there's damage or liability that occurs along the way. And I already addressed the issue of when does the risk of loss transfer, and I think that it should generally be viewed as being something that transfers based on who has control over whether damages or problems can occur. All right, and the last issue here is insurance. Insurance is actually a really big topic, but again, tends to be one of those topics that people overlook. I always recommend that when you see in a contract, and this again goes for really any contract, if there's an insurance requirement, the best thing to do right off the bat is to take that insurance requirement, send it to your insurance broker, and see if you're covered. If you're not covered, if your current limits of liability are not covered by your insurance policy, ask how much it costs to get that insurance. This can be really, really instructive and also a deal breaker for some contracts. The reason is that sometimes you have organizations that are used to doing many contracts. They have a standard insurance requirement that they ask for everybody to adhere to. Artists tend to be in a little bit of a different category sometimes. And so things like professional liability insurance are absolutely not feasible for most artists to get. If you're an architect, an engineer, a contractor, a veterinarian, a lawyer, a dentist, then you can get professional liability insurance. But for anybody else, professional liability insurance or errors and omissions insurance is very difficult to get. This can be problematic for artists, especially if they're coming in and designing things, and that design process can absolutely result in liability. It's very hard to be covered. So make sure you understand what's being asked in terms of the insurance coverage, and make sure that you get a really clear answer from your insurance broker or agent telling you whether you're covered and how much it's going to cost if you are going to be covered. One way, and I am not an insurance broker and I am not an insurance lawyer, so I am not giving advice here about this, but one thing that you can ask for sometimes is to look into the possibility of umbrella coverage. Umbrella coverage can give you a little bit more insurance on a more general basis if you're not covered enough in some of the other areas. One other insurance issue that tends to come up frequently is that generally these clauses will require a certain amount of automobile insurance. That may or may not be important for your particular project. So, and I would say more artists than other types of clients I've had, and certainly artists from big cities, sometimes don't have cars. And so if you don't have a car and or you're not going to be using cars in any way, shape, or form to perform the duties of the contract, sometimes you can get a waiver or carve outs, and that goes for other types of insurance requirements as well. So if you cannot comply, make sure that you're asking for a specific written waiver to make sure that you're not already in breach of the contract before you've even started because you can't obtain the insurance as set out. Okay, that's enough on insurance. Now it's time to wake up so we can talk about finalizing the contract. All right, at the end of the contract, you're going to see usually a series of paragraphs that are considered boilerplate. These are also things that tend to get skimmed over just because it's like, yeah, I know what that is, I know what that is. But it is really important to read through these carefully because little either omissions or additions of certain words can completely change the clause and the meaning. As we've all experienced this year in this difficult year of COVID, and many of you may have already seen in certain agreements that things like the force majeure clause, whoops, how did that all come up at the same time? All right, well, there we go, performance. Force majeure clauses are important because what that says is that in the event of something that we can't control, like COVID, like Hurricane Sandy, like so many natural events, then there has to be a way to get out of performing. So what we're seeing this year with COVID is that in a lot of force majeure clauses, the language wasn't necessarily specific enough to cover pandemic. So it maybe covers earthquake and hurricane, but not a public health consideration. So what we're seeing is that a lot of these force majeure clauses are being rewritten to take into account what is likely going to be an ongoing challenge that we have with COVID and other public health considerations. The second thing that's listed here, non-waiver, is another boilerplate clause that you'll see oftentimes written out. And what this means is that if you give the other party some slack in performing any of the terms of the agreement, you're not waiving the contract, you're not waiving the terms in the future. For instance, if somebody is obligated to pay you on March 15th for your performance based on the milestones, you get to March 15th and for whatever reason they can't pay you, they promise you it's going to be a little bit later, you agree, you get your payment April 1st instead. That does not mean that the April 1st payment can be 2 weeks late or that any payments down the road can be 2 weeks late. Each payment is still due when it's supposed to be paid. Just the fact that you've been flexible on one part of the contract does not mean that you've waived your ability to enforce the rest of the contract for the rest of the term. So I hope that's clear. If not, we can certainly talk more about that because this does come up frequently in terms of dealing with the realities of life. You know, contracts have to be a little bit forgiving to take into account how projects actually happen. And the fact of the matter is that we do tend to have to give a little bit and sometimes waive the schedules and other obligations under the contract to make sure that we can move forward. All right, and finally on this list, assignability. Assignability refers to whether the person that you're contracting with or whether you can assign your obligations and duties and responsibilities to another party. When we're talking about creative contracts for artists or artisans or anybody else from whom things are purchased or commissioned because of their talents and their specific styles, that's generally not going to be assignable. So when I hire an artist to do something, I want to make sure it's that artist that does the project. I don't want that artist to decide that because their friend over here hasn't had work in 10 years, they're going to go ahead and give the project to their friend instead. They feel bad about the fact that their friend's been out of work and they've got too many, you know, obligations on their plate. So I'll just assign this contract. No. You cannot assign contracts like that. I mean, unless the language says you can assign this to anybody you want. Generally speaking, artists are expected to actually do the work themselves and not delegate it to somebody else. On the other side, when you're talking about a commissioning party or someone who's purchasing the work, sometimes that party does change. You know, companies get bought and sold. Galleries get eaten up by other galleries. You know, so you've got situations where sometimes the party who is commissioning the work or purchasing the work or entering into whatever the agreement is, that party does change, and that might be fine. What we'll see in assignability clauses is either, you know, you may see a blanket prohibition on assigning any agreements. On the other hand, you might see that the artist is not allowed to assign the agreement, but if the commissioning party or the other contracting party is bought by somebody else, a majority share of their interests are bought out, then it can be assigned. And in a lot of cases, as the artist, you are going to want that assignability on the other side because you want to make sure you get paid, and you want to make sure that the next person who takes over, the next company that comes in and takes over, that they're obligated to pay you as well. So assignability is something that should be considered, and depending on the specifics of the project, may or you know, may be more or less appealing. Okay, still along the lines of the boilerplate language, we've got interpretation. So you'll see generally some sections at the end that pertain to how we read the contract. How do we interpret the contract? One is severability. Again, a word that we don't generally use in everyday conversation, that can be very important in the world of contracts. Severability is actually just as it sounds. It's about severing, but more like a starfish than a human being. So it's the ability to cut off one part of the contract and not affect the rest of it. So if you cut off one aspect of your agreement, the rest of it survives. You don't want to kill a whole deal because one part of it changes. So there will generally be language that allows for a piece of the contract to go away if it, say, you know, zoning regulations change, or something about what you originally agreed on becomes completely not feasible down the road. It's a way of retaining the bigger picture and the greater good without having it collapse because of one change. But important to pay attention to, though generally the severability language is going to be very standard, and you're not going to see a lot of differences in those clauses. And then we talked about this at the very beginning, so bringing this all full circle, an integration clause is something that you'll frequently see in contracts, and this is very important when it comes to any oral agreements that are either predating the contract itself or that happen during the course of the agreement. So if you have verbal amendments or other verbal promises outside of the contract, be careful, because if you have this integration clause, which says that it excludes any agreements outside of the written agreement, then you can be in trouble if you try to enforce any of those oral promises. So essentially the integration clause limits the contract to the, as we say, four corners of the document. So we talked in one of our previous conversations about dispute resolution. So I'm just going to touch on these things relatively lightly, unless anyone has some questions afterwards, which we can get to in a couple of minutes here. And that is dispute resolution. So we want to see dispute resolution language in a contract as well, so that if things do go wrong, we know how to address it. Again, contracts should be sort of a roadmap or a guide to help you along the way. And so if you get to a point where there's a dispute, what you'll see generally in contracts is a provision that deals with notice. So who do you need to notify that there's a problem? Usually there's an address. Sometimes there will be copies to an attorney or other parties involved in the agreement. So notices. And it should list you as well, whoever, you know, whether you're the artist or another party, you should definitely be included in any notices that need to be given. Process. So the dispute resolution process will be addressed, and we'll talk briefly about what those different options can be. I like to always start with a good faith effort to work out problems, because that's generally where problems do get worked out. And I think having it in writing sometimes encourages people who might be otherwise inclined to just jump right into being more conflict oriented to take a step back and think about just having a sit down conversation and try to figure out whatever the dispute is. The last thing on this list, attorney's fees. Very important to have a mention of attorney's fees if you want to be able to recover attorney's fees. If attorney's fees are not specifically called out, and this is not just me being self-serving, but if attorney's fees are not specifically called out in an agreement, then there may not be any basis, unless there's a specific statute that applies, there may not be any basis to get recovery for the cost of attorney's fees in resolving disputes. And as I'm sure many of you can imagine, attorney's fees sometimes are the biggest part of the dispute resolution costs. So very important if you want to be able to protect that ability to make sure that there's some mention in there of recovery of attorney's fees. Okay, and then we get to finalizing the agreement. So two parts to pay attention to at this finalization stage. Number one is exhibits and schedules. Do not gloss over exhibits and schedules. That may be where the most important information lives. Oftentimes exhibits and schedules will set out the heart and soul that we talked about earlier in interchangeable exhibits and schedules. So it may be that you've got a relatively formulaic template contract, and all of the details of your specific project are laid out in that exhibit. So don't just gloss over that. Make sure you're reading those very carefully and closely to make sure that all the details that are listed are appropriate and accurately describe the relationship. Schedules may lay out milestones and payments. So again, very important, especially if we're talking about how you get your money for the project. Signatures are, of course, no part to gloss over either. We need signatures on these contracts, and that is, of course, they have to be in blood to seal the deal. No, not really. They don't have to be in blood. You can sign with a pen. And now, of course, more frequently, electronic signatures are being accepted as well. So make sure that the language of the agreement covers the ability to provide signatures both in electronic format as well as in counterparts, meaning that things can be signed by one party in one place and either emailed or faxed. I don't know if anybody uses faxes anymore, but conveyed, that signature can be conveyed to the other side. The other side can sign separately, and those documents together will create one complete agreement. So it may be that you have two signature pages, one person's signature on one person's on the other, or you may have one page that has both together. So making sure that however you want to execute that agreement is something that's appropriate and allowed by the contract is important. All right. So again, just to touch one more time on these things that I think are super important: consistent communications, honest communications, and forward-thinking communications are so crucial in making sure that contracts move forward as smoothly as possible. Keeping those lines of communication open. Don't lie. I know that sounds obvious, but it's amazing how when people are worried about falling behind in their schedule or feeling guilty about something that they maybe should have done better and didn't, you know, sometimes we're tempted to stretch the truth. Don't do that. Be honest with the other party. And really, honesty is the best policy is not a saying for nothing. It really is the best policy, and it's the way that you're going to most quickly resolve any issues that come up in the course of performing agreements. And then finally, thinking ahead, very important, having an eye down the road so that you can see if there are likely issues coming up in the future, in the near future or far future, and then communicating those so maybe you can get ahead of it. And there may be some ways of resolving potential future problems that you see coming down the road that you haven't thought of, and the other party can be helpful in making sure that that happens ahead of time. Okay, very quickly, so that we can get to questions. Default or breach and remedies. So what is default? Default or breach can mean failure to perform or failure to adequately perform, and it can be accidental or intentional. So anything that causes a break in the contract is going to be considered potentially a default or breach. Generally, in the contract, there is a right to cure, or meaning that you can try to fix whatever the problem is before any remedies are available to the other party. But again, communication is important, and understanding what that time to cure consists of, and making sure that everybody's on the same page as to how any problems are going to be resolved. The problem is once you start down that road of having a default, that's when you risk getting into a situation where one party is saying it's your fault and the other party is saying no, it's your fault, and then you end up with entrenched positions that are more difficult to address. All right, so if we do have a problem, whether it's a problem that ends up going to court or not, there are generally several areas of remedies available. If we're talking about a really big problem that's going to cause irreparable harm, injunctive relief may be possible for breach of contract, and that means that you go to the court and ask the court to stop the other party from doing something or from not doing something. Second is monetary damages. Obviously, that has to do with money. So actual damages that you can show, or if there are if there's the ability to get statutory damages under the law, that would all fall under the umbrella of monetary damages. And then the final area of remedy would be specific performance. I talked a little earlier about how contracts in the art world tend to not be assignable when it comes to the artist's performance. What's required here is specific performance, meaning that a specific person needs to do a particular thing because that is what was ordered or agreed on. So oftentimes in creative projects in particular, specific performance would be a particularly important remedy to access because of the unique nature of art. And then again, we talked about this more in one of our previous conversations, but just to briefly go through resolution options for disputes, and this can be laid out in your contract as well at the end. Mutual agreement, meaning having that conversation and coming to an agreement. Mediation, meaning that you have a third party, neutral person who listens to both sides and helps you try to resolve it, so helps you try to settle things. Arbitration, which is again a third party who's neutral, but in this case, that person will listen to both sides and make a decision. That can be binding, meaning that that's it, you can't go any further, or non-binding, meaning that if you don't like the result of arbitration, you can appeal it to the courts. And then litigation is the final step here, and that is taking your dispute to court. All right, I believe we are now on our last slide, which is avoiding disputes. Again, covering some of the material that we did in more detail previously, but in order to avoid disputes and have the basis for forming solid, clear contracts. Keep notes, confirm things in writing, i.e. with contracts. Make sure you read and understand your contracts. Keep a copy, especially a signed copy if you have a signed copy, but do keep a copy. That can be very crucial down the road. Remain calm, communicate, have empathy. All of those things help in establishing solid agreements as well as resolving any problems that come up. And if all else fails, contact an attorney. Attorneys can help. There are attorneys for the arts organizations all around the country. If you cannot hire the biggest and baddest firm in your city, but use attorneys as a resource. All right, that is the end of my presentation. That was a quick pass through a lot of information, but I am happy to answer some questions now. Katie, I imagine you've got 1,000 of them in your queue now.
I got a handful.
Okay.
We have gone over the hour, so I just want to remind everyone that if you do need to leave and can't stick around for questions, we will be recording this and you can come back to it later on our YouTube page. Thank you, Sarah, for this information. It's really a lot of information to cover. Contracts are always a lot. I did pop into the chat box a link to a previous workshop that we did back last August, where we basically walked through these same topics you did, but with a specific lens to the City of Phoenix's public art contract. And we actually looked at an example of that contract. So if anybody else tuning in wants a more specific look at the way the City of Phoenix organizes their contracts as like an example, check out that on our YouTube page as well. So I'm going to start with the first question in the chat box. And as we're going through this, please feel free to type in any more. Does a contract protect intellectual property rights if not explicitly stated in the contract?
That's interesting. I'm not sure I can answer that in a simple way. A contract is not going to protect the intellectual property rights. Intellectual property rights are protected through other mechanisms, so copyright, trademark, patent. If a contract specifically states who owns intellectual property, then that's going to definitely address that issue. And certainly if there are licenses that are stated in a contract, then that's going to affect whether intellectual property is protected or not protected within the context of that contract. So if a contract doesn't mention intellectual property rights, that does not mean that an artist doesn't have copyright in their work. Just because it's not mentioned in there doesn't mean that that you can't go and register that copyright with the Copyright Office. It also doesn't mean that in the event that there's removal, relocation, damage, destruction, any issues having to do with the treatment of the artwork, that Moral Rights and Visual Artists' Rights Act laws don't apply or state equivalents don't apply. So if it's not mentioned in the contract, what generally applies is whatever laws are on the books, meaning federal or state law that would pertain to the intellectual property rights of the artist. And again, we can talk about this more in a couple of weeks. If the intention is to transfer any intellectual property rights, generally speaking, you need to have a writing that is signed by the copyright owner to transfer rights, and certainly to waive any of the moral rights. And the last point I would make very briefly is that licensed rights, licensing the ability to use some portion of intellectual property can be made in an oral context. So again, doesn't have to be stated in the contract, but if you have that saying that oral agreements outside the agreement are not going to be enforceable, then you may have a problem actually enforcing anything that's not in the contract.
Great. Okay, I'm going to skip down to the next question. What is the best approach to present a contract, say, freelancers who may not be accustomed to signing contracts?
What's the best way to approach a contract?
it says, what's the best approach to present a contract? This question came from Nita. Nita, do you want to unmute yourself and clarify your question?
I mean, it sounds like there's a concern over people being turned off by contracts, so that if you've got people who are not used to signing contracts, how do you get them to agree to sign a contract? And if you're the contracting party, if you're the one who's actually reaching out and wanting to hire somebody, then you have the ability to insist on a contract for sure. So that's the bottom line. I suppose that doesn't help in making people feel more comfortable about the contract. So I would approach the contract from the standpoint of presenting it as a communication tool, presenting it as a roadmap for the project, and trying to be very upfront about the fact that this is a way to ensure that we're all clear on what the obligations are, what our responsibilities are, how much you're going to get paid. And in fact, in a lot of circumstances, it's required to have a contract in order to be able to open up an account or do whatever process needs to be done in order to pay invoices. So contracts can be required for a particular situation. If they're not required, then at the very least, they're highly useful in terms of laying out expectations and making sure that everyone's operating on the same page.
Nita, did that answer your question? I don't think we have sound from her.
Well, if not, please put something else in the chat.
Yeah, hopefully that was able to address the question. And then I've got one more, and then we'll wrap it up for the day. Would exhibits and schedules sometimes duplicate information from the duties, representations, and warranties section?
It's possible, and certainly, nobody's perfect, and lawyers, I'm sure you'll be surprised to know, are no exception. So it's possible that you'll see the same things addressed in different places in a contract, but it is always best to read through the contract and make sure that the information is consistent. So you don't want to have two different places addressing the same topic with inconsistent information. And what I like to make sure is that the exhibits and schedules generally stick to the scope of work that needs to be done and the payment that's going to be made for the work. So that's generally what you're going to be seeing. You might see other documents attached that will help. So if we're talking about a big construction project, there may be other documentation that applies. If you're talking about a subcontract where an artist is subcontracting with somebody else to do a portion of the work for, say fabrication or anything else, it may be that one of the exhibits or schedules will be the general contract or terms from the general contract that need to be passed through. So it can be any number of things, but generally speaking, you don't want to have the same things addressed in two different places because you risk having inconsistencies.
Sarah, thank you so much for all this information. Ed and Mitch, do you guys have anything else you want to share?
Just want to say thank you, Sarah, and thank you for everyone for coming out to today's workshop. And I don't know if Ed, if you want to close it out today.
Thanks so much, everyone. Thanks so much, Sarah, for being so thorough in all this great information. As Katie mentioned right up front, this will be online probably in about a week as a resource for everybody to refer to, because there's a lot here, and we really appreciate your thoroughness, Sarah. And thank you, one and all, for joining us. The next workshop next week will be Bill Dombrova covering some digital software. And I think that'll be something that everybody's going to want to learn more about. They'll be diving into SketchUp, I believe. So stay tuned. Please log in and join us again for these. And we'll see you, Sarah, in 2 weeks.
Thank you very much.
Thank you. Bye.
Have a lovely day, everyone.